Hey guys, I'm Jamie Wacenske,
And I'm Dana Bellingrath.
and we're the family law attorneys with Matheson and Associates, and we're here with our First Friday video. And with the First Friday series, we give a free 30-minute consultation for whatever issue that we're talking about in the video happens to be, if you wait for the code at the end. So for those new viewers, thank you for watching. For old ones, welcome back. Today our only topic that we're going to talk about is contempt in general, the process for that, and the possible remedies. So first we're going to talk about just contempt generally. There's two types of contempt. One is direct and the other is indirect. Direct contempt is when you do something to interrupt the court proceedings, or if you do something possibly inappropriate in front of a judge while you're in court, then the judge can just hold you in contempt right there, because that's in the eyesight of the judge. Whereas indirect contempt, there's quite a few reasons why you can be held in indirect contempt, but the most common one is because of a violation of a court order, which can include child support orders, child custody orders, equitable distribution orders, or even alimony orders. So I'm going to turn it over to Dana so she can describe for you the process of what to expect.
Sure. So if you have an order and the other party is not following the terms of that order, they're not doing the things that they're supposed to do, the most common method for enforcing that order is to file for a motion for an order to appear and show cause. It's that / motion for contempt. It's sort of combined here in Wake County. And the purpose of that is you're asking the court to order the other one to come before the court and prove why they should not be held in contempt. It's presumed then that you've alleged that they're in violation and that it's willful, and they need to show the court why it's not. That shifts the burden to them. Whereas if you filed just a motion for contempt, you maintain the burden. You have to prove to the court that they have violated this order and that their violation was willful and they should be held in contempt. So typically we go the route of filing a motion to show cause, or is the short form, but it's asking the court to enter an order requiring that they come before the court and prove why they should not be held in contempt.
Yeah, and speaking of burdens, for remedies, we have criminal or civil remedies with the court, and the burden of proof for criminal is proof beyond reasonable doubt. So if you're filing this particular order for proof beyond reasonable doubt in criminal contempt, then you need to make sure you have enough evidence to go ahead and make sure they're punished under that rule. Whereas civil contempt is by greater weight of the evidence, and with greater weight of the evidence, all you're doing is basically showing that, hey, this happened, there's an ongoing court order that's in effect, and I want the court to comply. So I specifically said an ongoing court order in effect because with criminal contempt, it means you want them punished for a previous violation. Whereas civil contempt, you have an ongoing order, the order is still something they can comply with, they're just not doing so. So you just want the court to likely assess attorney's fees, because you can't get attorney's fees for both criminal and civil contempt. You can only get it for civil, and whatever you feel like you're owed to compel enforcement for the other party. So for criminal contempt, they can face jail time, a censure, and up to $500 in fines for each violation. Whereas civil contempt, they have typically, you find this in child support cases, but they have what's called a purge payment, where if you're asking for attorney's fees plus whatever you're owed or whatever relief you're entitled to or whatever you want the court to enforce, then you have civil contempt, and that is going to likely still put the other person in jail, and when they pay that quote purge payment, it's basically like bail, and that will satisfy whatever claims that you had for court. So basically that you're entitled to also have a court appointed attorney, but oftentimes people do, either if you don't qualify for a court appointed attorney, or if you need to find your own attorney because you don't necessarily agree with the court appointed attorney and their advice, then you can go ahead and give us a call. Our code for this month is MSC 2025. And again, if you feel like you need to file a motion for an order to show cause, or if you've just been served with these documents and you want an attorney from the start, we're happy to help you. Just send them on over to us, and we're happy to have a free 30-minute consultation. See you guys next month.